Right. Hi again, Felicity. Today we're going to talk about some questions and answers on maintenance matters. One of the questions that pops up quite frequently on both our groups are people that are so scared and that are so terrified of going to court. They don't know what is their responsibilities. What do they need to prove? What do they need to bring? Obviously, they need to bring the application form, the J101. They have to bring the supporting documentation. But what can they expect in court itself? Once they have everything ready, what can they expect? Just your perception there.
Yeah, courts can be very intimidating for the first time, and particularly if you have been through it and you've had a really bad experience, then it always your perception is that it's a hostile place. So I always say to people, if you're going to the court, just remember, one, that these are people doing their jobs, and to just try and be as informed as you can about what to expect. So what to expect, there's a Maintenance Act, and that they should be following the Maintenance Act. And the best way to ensure that is to print out a copy of the Maintenance Act. If it's a first application, focus on those sections, and I always say, just read the preamble, because the preamble says the best interest of the child. So, and that's your reminder, and to remember to just breathe. If you're feeling nervous, just breathe. If you say you don't understand, ask them to explain. If they're just throwing sections around or whatever, just say, please, can you explain that to me, so that you are better informed. But I always say, print out the Maintenance Act and take it with you, so that if they're deviating from that you can say, with all due respect, I have a copy of the Maintenance Act here, and in this section here says that this is what should be happening. So we seem to have deviated from that. Can you explain why?
How would you suggest? We've seen it so many times that only one of the parties have legal representation, and that legal representative is actually taking over and bullying the applicant into accepting a lower amount, which that attorney's client can well afford. What would be your advice to people?
I would say that if you feel that the process has not been followed, and that is a proper interrogation of the affordability, then, and that can also include that they haven't brought the supporting documents, then I say to them, ask them to postpone, or not postpone, but to adjourn for 2 hours or an hour, because you are there, you've made the effort, you have all your documents, they've not brought supporting documents, to actually compel them to go to the nearest bank, because most magistrates' courts are in a town centre, to adjourn it for an hour, and they must be ordered to go and get a copy of their bank statements, the very least, and come back to court, so that court process can continue.
We also see that quite often, and that's the major reasons for the delays in specifically with first applications, that people pitch up, or the father pitches up with no documentation, although in the documents that were served on him in terms of the regulations, stating that he has to bring certain things to court, they just simply don't bring that. So it's actually a very good idea to ask for a short remand for them to collect the banking statements, for example. But now sit with a different scenario where, how do you interpret those banking statements? Most of the maintenance officers, maintenance investigators, or even the attorneys, they don't know how to interpret the banking statement. What would you do? What can one expect? What should you look at once you have this banking statement?
So
because it's just debits and credits. So what would one look for in order to further your case? What would you look at in a typical banking statement then?
So I think the first thing is that maintenance is a priority payment. So we often see debit orders going off for various debt, cars, clothing, Netflix, DSTV, whatever, is to look for those kind of transactions on a bank statement. because they can't go to jail for debt anyway. That, you know, that the excuse cannot be affordability. So you can't just look at the bottom line and go, but he's only got like 2,000 Rand left. It's looking at the breakdown and looking at where the money is going, and arguing that maintenance is a priority debt, that they need to go and renegotiate those debts.
Sure, and it also speaks to luxuries. For example, I mean, like you said, luxuries like Netflix,
Yes.
or he can be a smoker, or you could see, but you know what, he spends a load of amount at the local off sales or something like that.
Exactly.
That is shown considered luxuries.
But not just that, also huge cash withdrawals, because I mean, some people are very devious and they don't want those reflected on their bank statements. So they either transfer cash amounts to another bank account, or they withdraw cash because they don't want it on record. Is for those withdrawals or transfers to actually be interrogated, because where is that money going? What is it being spent? The onus should be on them to provide slips, because we know there's always an emphasis on the applicant. Where are your slips? You're saying you spend 4,000 Rand on food. Where is your supporting evidence? So likewise, it should be, where are your slips? What have you spent this 5,000 Rand on? Or bring those bank statements. You've only provided one bank account. Where are all the other bank accounts? You know, because if you're transferring to a separate bank, whose accounts? It could be the new spouse. It could be various things that, you know, ask those questions. But we also see, Eugene, maybe you can answer this, is we see the withhold of that information to the applicant.
In terms of Section 5 and 7 of the Maintenance Court Act, the maintenance investigators actually tasked to investigate that. So there is a responsibility on the maintenance investigator to scrutinize those type of banking statements. They have the ability to apply to the courts to say, and to the different banks to say, but you know what, give us the statements of the father so that we can see. If there's a reference to he paid the money to his wife, or his current wife, or to his girlfriend, or to whomever, then the maintenance investigator has the power to ask for a court directive to investigate that account where it's been paid into. So those are all things that are available to the complainant. Is it being done in practice? No, it's not being done in practice. Mostly because, you know what, most courts only have one maintenance investigator, or they might group a couple of courts to have only one maintenance investigator. And they are overburdened. They don't get to all of those. So unfortunately, in terms of the Act, it is available. Those recourses are available for the maintenance investigator to investigate those type of accounts, definitely.
Sure. Okay, but it's first appearance for an applicant, and this is all happening. Okay, so she is entitled to request, if it's a first application, to request for an interim maintenance order, and then it can go to a Section 6, you know, where there is all this information is then requested by the maintenance investigating officer.
Absolutely. What often happens practically in court is that the non-paying father, they are very clever, they are wise, and they're misusing the system. So what would often happen is that they would just dispute paternity, and they know that they cannot proceed, because that is one of the prerequisites. You have to be the biological father of the child in order to have the liability and the responsibility to pay maintenance. So what would happen in court is that they would just say, but you know what, I'm not the father, and then the matter needs to be postponed for a DNA test.
Okay, on that particular point, there is a document that is in the file that they are obliged to sign.
Yes, that's correct. That is the paternity form. That is where they say, admit that they are the parent.
Which most of them do.
Most of them do. Is that a valid court document? No, it's not. Could it be used as evidence? Yes, sure, it could. It could. That could speak to Section 36 of the Children's Act, where there's a presumption of parenthood or fatherhood.
Sure. Okay. So why don't the courts address that issue first, as like okay, we're about to start this process. Do you acknowledge that you are the father?
That is what needs to happen. Most people think that once they go to court on their first application, is that everything will be solved in terms of the Section 6 inquiry, the informal inquiry, on that day. But that's not what's happening in courts. The Section 6 of the Maintenance Court Act clearly states and say, but you know what? The file gets handed to the maintenance officer. The maintenance officer needs to investigate the matter and then make a recommendation. So what would happen is, in an ideal world, is that before the people go, the mother and the father sits in the maintenance officer's office to do an informal inquiry, that investigation has already been done. So all the banking statements has been scrutinized. The paternity has been sorted out. That needs to be sorted out before it goes to a Section 6 inquiry, and that is not happening in courts.
Okay, so is it possible for us to encourage applicants when they arrive at court before proceedings start to say, can we, deal with paternity? Does the applicant acknowledge paternity at the onset of things?
That is the responsibility of the maintenance officer and the maintenance.
Okay, but it's not happening. So can we, as applicants, request that?
Of course you could. Of course.
Okay, so let's encourage, because we see this as a delay tactic. So let's encourage applicants to determine this at the onset, because if they then should be given that document, because then they can't really come back next week or the next maintenance appearance and go, hang on, but like, I want paternity test. I don't think I'm the father. Then they need to motivate why suddenly they don't believe they are the father.
Because we see that happening quite often. They go to court for 2 or 3 remandments, and a time lapse of probably 3 or 4 months has already gone by, and then all of a sudden they've got doubts if they're the father. So then there's another delay of another 2 or 3 months, and they get away with it, and that's totally wrong. That's totally wrong. So yes, the advice would be to on the first application, inquire. Put it on record. Ask the maintenance officer to ask that question pertinently, to ask the father, do you dispute paternity? If he disputes paternity, right there and then the Section 21 needs to be invoked, where they need to be sent for a DNA test, and that needs to be established that he is the father, and then proceed from there onwards.
Yeah, because just help me here, because my understanding is that if a child is born out of marriage, it is automatically assumed. There's more acknowledgement if one is in a marriage. But we are also seeing people who have now got divorced, and there's an arrears application that they've been married for 10 years or whatever, and suddenly they go, hang on, I want a paternity test.
If parents, if they are married, right, and there was a child born within the marriage while they were married, then there's a presumption that he is the father.
Sure.
That he's the father, and then the onus is upon him to dispute that and to prove otherwise.
Sure, but I for me, and I know that this is placing a huge amount of responsibility again on the maintenance courts, but I just feel that it should not be that easily accepted, that it should really be, okay, so why are you were married for 10 years, you fathered this child for 10 years, you have been divorced for 3 years or 4 years. Why is it that I believe that they need to submit compelling evidence to request a DNA test?
Absolutely.
They can't just say, oh, I doubt, but the child looks like him or whatever. They must motivate it with concrete evidence. And I just see this with a lot of the procedures, it's just an automatic thing, and there's not enough interrogation about this. And that's why it's being used as a delay tactic. And again, I'm going to bring it back that this is, again, just a different kind of behavior, trying to manipulate and control the money and punish. But more than that, when this comes up, for me, it's a form of sexual harassment, because it casts aspersions on the woman's sexual behavior, particularly if she's been married, because he's insinuating that she had an affair.
Yeah.
Exactly,
Yeah.
that she had an affair. So now that gets brought up subconsciously in people's minds, and her character is discredited. You know, and that's the way that we're socialized. And for me, so there needs to be proper interrogation. You know, with all why are you suddenly 6 years later, 16 years later, now demanding a paternity test?
Sure, and I mean, there's also the section 36 of the Children's Act, which is the presumption of paternity, where and that the act is very clear that, you know what, if there's any substantial proof that you were in a committed sexual relationship with that person during the time that that child was conceived, that you are deemed to be the father.
Sure,
And
but
based
it's
on,
just
based on that, an interim order could at least be made for maintenance
sure,
pending
but
a test.
but we're seeing them not wanting to do that because now suddenly there's doubt. You know, and you know, I'd love to, like, this is me, I'd love to say to this person raising this question, how many DNA disputes have you brought to the attention that you've gone for DNA tests? How many?
Yeah, sure. Now, this is a question that's a burning question that we talk about a lot. Felicity, thank you so much for your time. We'll speak soon. Thank you.
Eugene.